Foreign Countries Act and the Public Officers Ethics Act 2003. Prince Kanu, swore an affidavit stating that he had been authorized by Mr. Nnamdi Kanu to swear the affidavit because Mr. Nnamdi Kanu could not swear one since he was in detention and was prohibited from swearing an affidavit. Prince Kanu stated he had met Mr. Nnamdi Kanu on 27th July 2021 at about 3 p.m. at the headquarters of the State Security Services in Abuja, Nigeria, and he believed the facts given to him by Mr. Nnamdi Kanu to be true. Prince Kanu deposed that on 12 May 2021, Mr. Nnamdi Kanu entered Kenya legally as a British citizen and settled at a temporary location in Nairobi. On 19th June 2021, Mr. Nnamdi Kanu drove to Jomo Kenyatta International Airport on a personal errand. As soon as he parked the vehicle and alighted, several agents of the Nigerian government accosted and abducted him, handcuffed him, bundled him into a vehicle, and sped away. The abductors took Mr. Nnamdi Kanu to a house within Nairobi and chained him. They did not show him an arrest warrant issued by a court in Kenya or an extradition order. He was also not informed that there was a warrant or extradition order. Prince Kanu stated that the abductors beat Mr. Nnamdi Kanu in turns and tortured him while in chains until he fainted. Mr. Nnamdi Kanu was kept in detention for 8 days, was not allowed to bath or was fed on stale bread once a day and given non-sanitary water to drink. His plea to be given medications for hypertension and heart condition were ignored. The abductors did not produce him before a court of law in Kenya or other law enforcement facility. He was also not allowed to contact an advocate or make a phone call to anyone. Prince Kanu stated that on 27th June 2021, Mr. Nnamdi Kanu was taken out of the house, put in a car, and driven to Jomo Kenyatta International Airport, where the abductors forcibly bundled him into a private jet that departed JKIA at about 12 noon and arrived in Abuja, Nigeria, in the evening of same day and was detained at the Nigerian National Intelligence Agency headquarters. On 29th June 2021, Nigeria's Attorney General addressed a press conference stating that Mr. Nnamdi Kanu had been rearrested through the collaborative efforts of Nigeria intelligence and other security services to continue with the trial he was facing before disappearing while on bail. Prince Kanu further deposed that on 22nd July 2022, the working group of the United Nations Human Rights Council issued a statement condemning the abduction, detention, disappearance, torture, and expulsion of, and called for Mr. Nnamdi Kanu's unconditional release and payment of reparations. The statement termed his transfer from Kenya an act of extraordinary rendition and required both Kenya and Nigeria to fulfill obligations to recompense him. Prince Kanu again stated that on 13th October 2022, the Court of Appeal of Nigeria termed the subject's expulsion from Kenya to Nigeria as an act of extraordinary rendition and discharged him of all criminal charges. The Court of Appeal also barred any Nigerian court from trying Mr. Nnamdi Kanu on any crime. It was again stated that on 26 October 2022, the Federal High Court of Nigeria also held that the abduction, detention, disappearance, torture, and expulsion from Kenya to Nigeria was an act of brazen violation of Mr. Nnamdi Kanu's fundamental rights and awarded him compensation. The continued detention in Nigeria was also declared unconstitutional. Mr. Prince Kanu asserted that Mr. Nnamdi Kanu believes that the government of Kenya had a duty to protect him as a British citizen, having been allowed to enter the country and been lawfully in the country. So the respondents opposed the petition through grounds of opposition, a replying affidavit sworn by Dr. Engineer Karanja Kibicho, CBS and written admission, grounds of opposition. So here is what the representative of Kenya government and others put up as their defense against all of this petition, or against this petition. So in the grounds of opposition, the respondent contended that the petitioner had not satisfied the constitutional threshold in Anarita Karimi Njeru v. Republic, 1979 EKLR. There were no extradition proceedings to show that the government of Kenya was responsible for the extradition, and there is no OB record from any police station within, what the heck? Did they actually say that? Really? Okay. OB record from any police station within the country to show that Mr. Nnamdi Kanu was lawfully arrested and detained for purposes of commencing extradition proceedings. The respondents maintained that the petitioner, please bear with me. The respondent maintained that the petitioner, oh, that's not good. No, we need something soothing as a background, yeah? Something soothing, calm. I'm sorry. And a colorful too. Or maybe this. Let's leave this one. So they said the respondents maintained that the petitioner had failed to demonstrate with precision that Mr. Nnamdi Kanu was a person of interest by law enforcement agents. What the heck? Is this what their lawyers are in Kenya? Please pardon me, all right? Now, they asserted that, no wonder. So they asserted that some of the issues in the petition are on actions that took place outside the territorial jurisdiction of Kenya. How? It was the respondent's view that the petition is premised on hearsay because there is no evidence to show that Mr. Nnamdi Kanu was declared a prohibited immigrant under Section 33 of the Kenya Citizenship and Immigration Act 2011, or that a deportation order was issued under Section 43 of the Act. The respondents stated that the East African tourist visa issued in Kigali, Rwanda, was valid from 13th March 2021 to 11th June 2021. It was not possible for Mr. Nnamdi Kanu to be in the country on the same visa on 19th June 2021. It is the respondent's position that the petition had failed to demonstrate that it was police officers who arrested Nnamdi Kanu or that he was in custody of the Kenya authority. Thus, the petition does not raise a cause of action against the respondents. Replying the affidavit. It was deposed in the replying affidavit that the allegations of Mr. Nnamdi Kanu's arrest, detention, and extradition were facts not within the petitioner's own knowledge. According to the respondents, since 17th July 2019, Mr. Nnamdi Kanu had visited and departed Kenya on several occasions. His last date of arrival was 12th May 2021, and there is no evidence that he left the country. The respondent asserted that the persons who allegedly arrested Mr. Nnamdi Kanu had not been disclosed in the petition, neither at the place of his detention. The cooperation between the Kenyan and Nigerian government, as well as alleged extradition, had not been demonstrated and proved. They urged the court to dismiss the petition with costs. The petition was disposed of through written submission with written oral highlights. So the petitioner's submission. Do you want me to read that step by step, right? It's interesting though. So the petitioner's counsel submitted relying on the decision in Kituo Cha, Sharia, and 8 others, the Attorney General 2013 EKLR, that the subject having been within the territory of Kenya at the time was entitled to constitutional protection under the Constitution of Kenya. It was argued that The circumstances under which Mr. Nnamdi Kanu was removed from Kenya constituted a violation of his rights and fundamental freedoms guaranteed by the Constitution of Kenya, a breach of due process on extradition provided for in the Extradition Commonwealth Countries Act and the Extradition Contiguous and Foreign Countries Act. It also violated international law. The petitioner cited Article 21(1) of the Constitution, and the decision in CK, a child, through Repos International as our guardian and next friend, and 11 others v. Commissioner of Police / Inspector General of the National Police Services or Service, and 3 others in 2015, 13. And these are cases, here you get, these are like cases referenced to by the petitioner, that is Mazi Nnamdi Kanu. It was submitted that Mr. Nnamdi Kanu, having lawfully entered Kenya, was entitled to the protections and privileges afforded by the Constitution of Kenya, despite not being a citizen of Kenya. Reliance was placed on the decision in SNV Cabinet Secretary for the Ministry of Interior and Coordination of National Management Services, Director General, Kenya Citizens and Foreign National Management Services, and Attorney General 2016. So this is them like, okay, referencing cases that protect Nnamdi Kanu and every other person who, even if they are not Kenyans, if they enter Kenya lawfully, they must be protected in this instance. So they didn't. The petitioner again submitted that the conduct of the respondents and their agents in the disappearance of Mr. Nnamdi Kanu from Kenya fell outside their constitutional mandate and duty as envisaged under Executive Order Number 1 of 2023 and Section 24, 28, and 35 of the National Police Service Act, because the first and second respondent could not account for Mr. Nnamdi Kanu's removal from Kenya after his lawful entry into the country. The third respondent was complicit in the carrying out of an act of rendition in violation of the Constitution and laws of Kenya. So the petitioner relied on Article 10, 24, and 29 of the Constitution, Article 12(4) of the African Charter on Human and People's Rights, and Article 13 of the International Convention on Civil and Political Rights for the contention that these provisions require strict adherence to the laws of Kenya pertaining to the process of removing a person from the territory of Kenya and submitting him to the authority and jurisdiction of another state. The petitioner relied on Section 11(1) and 12 of Extradition Foreign and Contiguous Countries Act, Cap 76, and the decision in Gunter Groshovsky v. Attorney General and Commissioner of Police of Prison, the Commissioner of Prisons 2009, to argue that due process on extradition was not followed. There was no warrant of arrest issued by a Nigerian court and endorsed by a magistrate in Kenya. Additionally, there was disregard of and non-compliance with Section 3, 5, 6, 7, 8, and 9 of the Extradition Commonwealth Countries Act. The court was urged to allow as prayed. So, respondent submission. This is the lawyers representing Kenya now in their response. The response submitted that the petition did not meet the threshold in Anarita Karimi Njeru v. Republic, 1979. They also argued relying on Rule 10(2)(c) of the Protection of Rights and Fundamental Freedoms, Practice and Procedure Rules 2013, Mutunga Rules, that the basis of the petitioner's allegation was hearsay information from Mr. Nnamdi Kanu's personal secretary and Nigeria's Attorney General, thus of no probative value. The respondent further submitted that the affidavit sworn on 10th September 2021 and 28th March 2023 by Kingsley Kanuta Kanu and Prince Kanu, respectively, amount to hearsay because none of them witnessed the alleged event as deposed in the affidavit. The respondents maintained that no affidavit had been sworn by any authorized officer from Nairobi Hospital to confirm the authenticity of the annexure, which is annexure of KK4 admission form attached to the supporting affidavit. So they are questioning the hospital visit. So the respondent further argued that no report of a missing person was made at any police station, and there was no application for habeas corpus filed in court. They relied on the decision in Ruben Wangi, the Director of Public Prosecution, and two others. So the respondent again argued that while Section 24E and G of the National Police Service Act confers on the third respondent power to detect, investigate, and prevent crime, that mandate is only discharged or exercised within the confines of the Constitution and the law. It is the respondent's duty to investigate if and when a complaint is made. They relied on the decision in Republic v. Commissioner of Police, blah, blah, blah. So there is more of their responses. Give me a sec. Okay, you know what? Let's keep going page by page. I don't want us to probably miss anything. Right. So this is them. So the determination. Upon considering the petition, so I want to believe that the determination is now the ruling, the judge. This is what they determine after listening to both parties, right? Upon considering the petition and argument by parties, the issues that arises for determination of whether Mr. Nnamdi Kanu's rights were violated, and depending on the answer to this issue, the appropriate relief to grant is violation of rights. So the petitioner argued that Mr. Nnamdi Kanu's rights and fundamental freedoms were violated because of the manner of his arrest, detention, torture, and transfer from Kenya. The respondents denied the claim of violation of rights and fundamental freedom. Okay, still kind of like putting them side by side now. To determine this issue, consideration of the facts on this petition is necessary. Some facts in this petition are undisputed, while others are. The undisputed facts are that Mr. Nnamdi Kanu is a British citizen of Nigerian descent. He lawfully entered Kenya on an East African tourist visa from Kigali, Rwanda on 12 May 2021 through Jomo Kenyatta International Airport. The following facts, however, disputed. According to the petitioner, Mr. Nnamdi Kanu was arrested or abducted on 19th June 2021 at the JKIA, Jomo Kenyatta International Airport, by people said to be abductors. He was taken to a house where he was chained, tortured, and subjected to inhuman and degrading treatment. He was denied basic necessities, including food and water. He was rarely given water to drink or bath, and was denied medication despite requests. After 8 days in captivity, on 27th June 2021, Mr. Nnamdi Kanu was driven to Jomo Kenyatta International Airport, put on a plane, and smuggled out of Kenya to Abuja, Nigeria, arriving in the evening of the same day where he was detained at the Nigerian National Intelligence Agency headquarters without extradition order. That's also a fact. Without, the court is now establishing all of the presented evidences now. You follow? Right. According to the petitioner, on 29th June 2021, the Attorney General of the Federal Government of Nigeria addressed a press conference and revealed that Mr. Nnamdi Kanu had been rearrested through the collaborative efforts of the Nigerian intelligence and security services so that he could be tried for the charges he was facing before disappearing while on bail. It was on that basis that the petitioner stated that Mr. Nnamdi Kanu